Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm terribly.
The behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue.
Okay.
Take him back. Court is standing in recess.
All right.
The name District Court of County, Washington, State of Michigan is now back to the
You may be seated, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you. That's called the case of the People versus Bloom.
Good morning, Your Honor. Sam Bernstein here on behalf, not exactly with Mr. Bloom.
All right. We've had numerous discussions regarding the defendant's participation, just so that the record is clear. The defendant left the courtroom during the course, or at the very beginning, at least I think at the beginning portion of the people's closing argument. Upon his leaving and reviewing some case law at that point, we adjourned it to the continuation of the trial to today. Looking at additional case law without a great deal on point, and I don't have that. Yes. We had started out with, I believe it's the Swan case, People versus Swan. That's at 394-451, which we knew about last week, to try to deal with Mr. Bloom's absence from the proceeding. This morning, I had told counsel that the court additionally found the case of People versus Palmerton. That's at 200 Mishap 302, the 1993 case. And the long and short of it is that the defendant, to have a valid waiver of his right to be present at trial, that has to be established on the record. My understanding is that the defendant does not wish to come out. He is up in the court's lockup, but does not wish to come out and be present for these proceedings. Is that correct, Mr. Bernstein?
That is correct, Your Honor. I have spoken with him, expressly relayed that he has a right to be at the trial proceedings. Mr. Bloom states that he does understand that and he wishes to waive that right and have the closing argument in his absence.
All right, very good. And you're satisfied that he understands and is knowingly waiving his right to be present during the trial?
I am, Your Honor. Today was not the first time that I spoke about it, and I do think that he understands that he has the right to be here and wishes to waive that.
All right. Does either side need I don't think there's any disagreement that Mr. Bloom is up here because Mr. Bernstein has talked to him. We could put on at least testimony of the officer or one of the transport officers to indicate that his understanding is that Mr. Bloom does not want to be present. Does either party think that is necessary given the representations of Mr. Bernstein?
I have absolutely no reason to doubt Mr. Bernstein. The only concern that people brought forward to the court was if there is a conviction and there's an appeal of that conviction, if Mr. Bloom may make representation that is not what he told Mr. Bernstein, I would request that the court make a very short inquiry of one of the transport officers that it's their understanding as well, if the court would be so inclined.
That may make sense. So if we could have, was it Officer White? Was it?
I do think Corrections Officer White is up.
Yes, if he could come out. Deputy White, if you could come to the podium, please. Mr. Allen, if you could swear him in, please.
All right, and do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State and spell your first and last name for the record, please.
Matthew White, MATTHEWWHITE.
All right. And you're employed with the Washington County Sheriff's Office
Yes,
and in the transport division.
that's correct.
All right. And you were in part responsible to transport Mr. Bloom to these proceedings today.
Yes,
And he was brought up from the jail to the lockup off of the courtroom. Is that correct?
yes.
All right. During the course of that, and in terms of getting him ready for trial, did Mr. Bloom make any representation to you or in any way indicate to you that he did not wish to participate in these proceedings?
Yes, he did. He just said that he felt like his trial was over and he didn't need to be present.
All right. And is it your understanding that he does not wish, based upon those conversations and his actions, is it your understanding that he does not wish to come out and participate in these proceedings?
Yes.
All right. Any questions from the people?
People are satisfied.
Any questions from the defense?
No, Your Honor.
All right. Thank you, Corporal. All right. I think we dealt with that matter. There is then the issue of an instruction to the jury. During a break while we had an opportunity to speak, I had an opportunity to speak to counsel. I asked them to draft something that they would believe would be sufficient to instruction to give to the jury. They have drafted, and we have a copy of the instruction that I believe the parties wish read to the jury. Mr. Bernstein brought up the point that not to necessarily read that, it could be read with my final instructions, but that the real issue was that there had to be some explanation or something to the jury once they came into the courtroom. And so I had indicated, if there's no objection, that I would read that. Excuse me one moment. That I would read that once the jury enters the room. The instruction that counsel has presented is that during the course of this trial, the defendant has chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Is that a correct understanding of?
Yes, Your Honor.
It is, Your Honor.
All right, very
Would the
good.
court consider giving it to the jury when they come in, and then also in the final instructions?
I would consider that. I certainly was going to give it on Mr. Bernstein's request once they came in to explain the defendant not being present. If you wish me to give that during the closing instructions, I could do that also.
If the court wouldn't mind, I would appreciate that, just so it's very clear that this is your new instruction, and when the court instructs the jury to take the jury instructions as a whole, I think it would be helpful just to have that included as well, but that is a piece of this trial.
All right. Very good.
I don't mind. It's belt and suspenders, so.
Haven't heard
I just want to say
that.
that.
Haven't heard that in a while, but yes, okay. Just want to make sure I have 11. I think then what I would do is, since Mr. Bloom did not testify, I would insert the reading of that instruction around that same point as the reading of 3.3 to defendant not testifying. I think, yep.
Sequentially, that seems to make sense. Thank you, Your Honor.
May be seated. Your Honor, the jury is present.
Thank you. Good morning, ladies and gentlemen of the jury. Initially, what I would do is I would give you an interim instruction and just tell you that during the course of this trial, the defendant has chosen to no longer be present for these proceedings. I would admonish you and ask you to remember that his absence should in no way impact your deliberations or your verdict. All right. Ms. Lundy, we're at the point of closing arguments. And I believe when we stopped, you were in the middle. However, you may begin again with your closing argument.
Thank you, Your Honor. Your Honor, with the court's indulgence, at this time, I'm going to end my closing argument. I trust that the jury remembers it and remembers what I had to say, and I don't see the point in sort of rehashing all of it. They've been paying diligent attention.
Okay.
If that's okay, if that pleases the court and defense counsel.
That is fine with the court.
Thank you. I do reserve any further argument for rebuttal closing.
Thank you.
Thank you.
Mr. Bernstein, closing argument.
Thank you, everyone, for coming back. That day, Rocky saw Jeff in the jail and found Jeff to be yelling, saying he didn't trust him. And we've been through this trial now together, and we've seen how that has all played out. And my question for you guys is, where's the beef? Really, where is the beef? There was a question posed to Rocky. Did he have any reason not to trust you? Rocky said, not at all. There were no problems between Rocky and Jeff. There was no history between Rocky and Jeff. I don't mean to minimize any impact from this on Rocky. The prosecutor in her closing did a good job of talking about the emotional connections that we have with nurses. I get it. My wife's a nurse. My grandma was a nurse. That's not exactly the situation here, though. This wasn't the cozy urgent care. Rocky said when he met Jeff, Jeff is just screaming uncontrollably. He's in fear for his life. He doesn't trust him. There needs to be an officer to calm him down. It's just not a normal situation. And I can understand how Rocky feels the way that he does. After he leaves there at first, there's no problems. Nothing hurts. He walks away. Then he starts talking to people. He starts retelling the story. There's his email. There's his medical records. The story changes. It does. The situation that we do have here is that there are two officers standing right there. Both officers said that they did not see Rocky hit that door. They did not see Rocky hit that door. They did not see Jeff grab Rocky. We watched a video twice. That video showed nothing at all. Of course, there was one major way that we could have resolved this. There was a camera pointed right at Jeff's cell, and no one talked about doing anything to see if that camera captured it. Instead, we were shown a video that showed nothing. I come back to my original question, guys. The original question I posed, where is the beef? And I don't mean motive, okay? This isn't an Agatha Christie whodunit novel, right? But like, why? The question isn't whether Jeff pulled his arm back. The question is, why did he do it? If there is no intent to commit a battery, then there is no battery. Without intent to commit a battery, there is no crime. Without a beef here, there is no battery. We asked you here for your help, and I get how we got to this point. Jeff is not going to get the benefit of the doubt. He was in jail. That's fine. I get it. A lot of what's been talked about in this trial has always come with an explanation. It's been glossed over, minimized, explained away as if these things don't matter. Does it not matter that Officer Navin testified that he was standing right there and didn't see that happen? That he didn't see Rocky hit the door? Does it not matter that Officer Tweedell was standing right there as well and did not see Rocky hit the door? We saw a video twice that didn't even show anything. We didn't hear about any efforts of anyone trying to get the other video. I mean, does it not matter that Jeff is having an emergency? Does it not matter that there's a perfectly reasonable explanation for this? That's not a crime. The guy's freaking out and doesn't want Rocky to touch him. He's talking about he's in fear for his life. Jeff doesn't want to hurt the guy. He has no beef with the guy. He has no beef with Rocky. I say that these things do matter. Jeff does deserve the benefit of the doubt. And legally speaking, he gets that benefit of the doubt unless you are really shown something otherwise. But we have not seen that here. Absolutely not. You are the only people that can help Jeff. And we have asked you here to listen, and we are asking you now for that help.
Thank you, Mr. Bertrand. Rebuttal.
Defense counsel says you are the only people here who can help Jeff. But that's not true. Because there were plenty of people who tried to help Jeff on the day that this happened. There were guards to get him the medical attention he wanted. A second guard brought in to make sure nothing happened. And Rocky brought in to assess his vitals and see if he needed emergency medical treatment. All three of those people tried to help Jeff on that day. All three of those people tried to get the defendant the help he needed to keep him safe, which is what I talked about last week. Safety is the priority of the three men that you heard from. That's their job. Defense counsel's asking, does it not matter that this guy is freaking out? Look at the law. Look at the jury instructions. Listen to the ones that you're about to hear and consider. Does the motive matter? No. And that his intent can come from all of the surrounding circumstances. And what does he do with that blood pressure cuff after he pulls it into that cell? Waves it around like a lasso. It's a game. It's a game for the defendant. Mr. Burnside says this video shows nothing at all. Except that that's not the case, because the video shows you exactly what Officer Navin testified to, exactly what Officer Tweedale testified to, and it shows you Tweedale standing there, frankly, making a better door than a window, blocking the view of the camera. Those men easily could have come up here and said, yes, I saw the whole thing. I saw Rocky get slammed. But they don't, because that's not what happened. They're focused on Jeff. They're focused on the defendant. They're focused on this person who's demanding medical attention, and they're so concerned they do it through the food slot.
Rocky told you how he had his arm, and he showed you, demonstrating he had his arm all the way out, bent all the way down. This isn't like somebody got grabbed by the hand and pulled in. This is somebody who's already extremely close to that door. The defendant's the only person that day who made a choice to compromise the safety of another human being. People are asking you to hold him accountable and convict him.
Thank you. Members of the jury, the evidence and arguments in this case are now finished, and I will now instruct you on the law. That is, I will explain to you the law that applies to this case. During the course of this trial, the defendant chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must affect your verdict. It must not affect your verdict in any way. Ladies and gentlemen, you have heard testimony from witnesses that are correctional officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. The defendant in this case is charged with the crime of assault and/or assault and battery. The prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon Rocky Isley. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Rocky Isley's will. It does not matter whether or not the touching caused an injury. Second, that the defendant intended either to commit a battery upon Rocky Isley or to make Rocky Isley reasonably fear an immediate battery. As used in these instructions, the words force or violence means the use of physical force against another person so as to harm or embarrass them. For a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against the will of Rocky Isley. Does not matter, as I've indicated, whether or not the touching caused an injury. You may be seated. Any objection to the instructions as given by the court?
No, Your Honor.
I have none, Your Honor.
All right, thank you. And on this matter, we will stand in recess on the Bloom matter until such time as we have a verdict and/or questions or inquiry from the jury. Thank you. Okay, court does call the case of the People versus Jeffrey Bloom.
On for the people.
Good morning again, Your Honor. Sam Bernstein for Mr. Bloom.
I have been informed that we do have a verdict, and that gets us to, I guess, another proceeding. And by way of caution, I asked Mr. Bernstein to talk with his client as to whether or not he wishes to be present for the verdict. Mr. Bernstein.
He does not wish to be present, Your Honor. He understands that he could.
All right, very good. I will assume that the waiver that was in place before is continuing. Would I be incorrect in that assumption?
I would agree with that assumption.
All right, very good. Are the parties ready then to receive the verdict?
They are, and for the record, the people would be fine with Mr. Bernstein's assertion to the court about that, about his client wanting to be present for the verdict. While of course the reading of the verdict is a critical stage of the trial, it has perhaps a different procedural effect. That people say in trusting Mr. Bernstein's assertion.
All right.
I'm likewise ready for the verdict, Your Honor.
All right.
All rise for the jury. Seated. Your Honor, the jury is present.
Ladies and gentlemen, the court is of the understanding that you have reached a verdict. Do we have the verdict? And that back to the foreperson. Ladies and gentlemen, the jury, who speaks for you? All right. And sir, you have reached a verdict. What is that verdict?
We have reached a verdict of not guilty.
All right. Would either side like the jury poll?
No, Your Honor.
No, Your Honor.
All right, very good. Ladies and gentlemen, I want to thank you very much for your service. We will send you back. I'll be back to formally excuse you momentarily. I know this has been a weird kind of journey having to come back, but I do appreciate your patience in helping us get through this. All right, thank you. Mr. Allen, you may take the jury.
Jury.
On this matter, is there anything else?
No, Your Honor.
All right,
No, Your Honor.
thank you. 14A stands in recess. He's here. And also Gavin, is it Wesleyan? Wesley?
Well, it's
Hello.
Hi, how are you doing?
Okay. Oh, they're in like 8 different screens. Okay, yeah. That's good on my eyes for this time of day. All right, where are we on this case?
Your Honor, this was adjourned 1 week. Ms. Salisbury indicated that, I think Mr. Wellesley as well, that they were trying to seek legal counsel. Total due at present with court costs $4,735.32.
All right, folks, where are you on this?
I guess I'll go first, Your Honor. Thank you for the opportunity to speak today. I want to start out by explaining that I requested the adjournment to retain an attorney, but I wasn't able to secure one within the week. We were calling attorneys that specialize with lease evictions, but nobody had the time to help. I would like to state that me and Haley have not been together since April due to relationship issues. And that's one of the reasons why my mom is involved. She's on the screen with her. She's done most of the talking between Haley and I. She's also communicated with Spice Tree Apartments. I lost my father in a tragic way on August 12th, so I haven't had the best headspace to do this on my own, and that's another reason why she's here. But to get things started, I guess for me, I'd already moved into an employee house free of rent and utilities in Ann Arbor on March 22nd. Before Haley moved into her apartment on April 14th, she asked if I could help her by signing some documents on her behalf. When I inquired about what my involvement would be, since I wasn't going to be living there at this time, she wrote me a text explaining that the manager had told her, saying that I wasn't going to be held responsible for anything. It was all just a workaround to help her get into the apartment. With everything Haley has been through, I decided to sign the lease info because I did not want her to be homeless, and her staying at the employee house obviously wasn't an option. I never filled out an application with my info. All I got was an email of an e-signature file of the lease, and this made me believe what Haley said was to be true, so I signed the lease not knowing I was signing to be a resident.
Okay. All right. And what do you folks, Haley, what do you want to tell me?
I also have a thing I can read. So Your Honor, thank you for the opportunity to speak today. I would like to explain my situation and how it led us here. I was approved for the lease based on a combination of my survivor benefits and Gavin's income. I was not in Ann Arbor yet because I was waiting to start a job here. I didn't start the job yet. He clarified on the phone that he wasn't going to move in at the time, but they still put him on. Yeah. And do.
I would explain this part right here.
And then the rent hasn't been paid because I don't have the survivor's benefits anymore. They canceled it in June. And then I was
Hadley, hold on, stop for a moment. What kind of survivor's benefits did you have?
I don't know exactly. It was just like SER.
Did you lose a parent?
Yeah, both of them.
And your siblings.
You lost both parents. Okay.
I'm
And
sorry,
in
Your Honor.
June, and in June, did you turn 21?
No, 20. Or no, April I turned 20.
April, you turned 20. Okay.
Yeah, I thought it was until I was 21, but I guess it's not. So that's why we're in this hole.
All right. Go ahead, ma'am. You want to tell me something?
I really do, Your Honor. I want to let her finish, but I also know she's very prideful. And this isn't a dispute, to be clear, about Gavin and Haley like against each other. But if I could read my portion, because I think you really do need to understand something incredibly crucial to the context of this. And then also some procedural errors that I have personally been involved with since June 19th that I think you want to be aware of. So I'm Andrea, I'm Gavin's mother. I've been helping Haley and Gavin navigate this situation, and I do want to clarify from the start, like Gavin did, that they're not dating and they haven't been in a relationship since April. I took on this role as a mentor and advocate to support Haley the past 2 years. I will get into that, and I know she feels uncomfortable with this, but even I'm frustrated and not sure how much more I have in my tank to help, and this young lady needs some help and guidance in this. 2 years ago, not only did she lose both her parents, she also lost her 3 baby siblings because her stepdad murdered everyone. It was a quadruple homicide. And I am mentioning this to you because though she was technically 18, and this is why I'm in her court, because this is all trickling down to today, and I'm not trying to just do the sympathy piece, but I need someone to understand this girl hasn't been guided. Because she was 18, she unfortunately, didn't have the assistance of anything else, but she was in that home and instantly became homeless because her home was a crime scene. And I didn't even know she was without a home already for 9 months at that point. Her and my son had been dating on and off. And once I discovered that, that's when I stepped in, because she has literally no mother, no father. All of her siblings are gone except for her 2 younger surviving siblings. And this has been a lot. Now I'm gonna cry because she never cries. So I know she owes the rent. She knows she owes the rent. We're not disputing that. But in addition to that, I want you to know that's why my son helped in the way he did in signing this. And he truly, from what I'll show you in the evidence if you need, he did not know he was signing a lease. He simply thought, because he's very naive, and he also should probably tell you he is not a reader. And he thought he was helping her out truly. And they split up in April. So, and he lived in an employee house, and that just further reiterates that there were some procedural errors and that the apartment complex did not do their due diligence in ensuring that Gavin was not a resident. He never sat there, he never met with them. And my request is, not that the money isn't owed, but my request is, after you hear all of this that had happened, that not only that both Haley and Gavin's names are removed from the lease, and that, let me tell you the rest. Thank you for being patient, by the way. That because of these personal losses, and what my son didn't tell you is the way he just lost his dad just 6 weeks ago was incredibly tragic. And so he's also got that currently going on. And she hasn't even begun to be able to process this grief, because for 2 years, we've been working to get her some housing. We're in her apartment with no furniture at this moment. She's had nothing here this whole time. And we've been waiting for assistance by waiting for a court summons so she could get on her feet, because she did have a job lined up. But now we're this far behind because nothing was served
Because they didn't.
until
Yeah.
the dates I have. I have a timeline laid out for you, by the way. If you do want it, we have it on Zoom. It has a lot of dates that I have all receipts of all my emails with them, never getting a return email, never getting any answers on the phone. Not only that, they withheld information from Gavin on September 3rd when James called my son back, because that's also the day they filed this court summons, and no one ever told my son that. And then the very last thing I want to say is that our request is not to not have the amount owed, although I do wish we had some way to work around some of this. But to have them both removed from the lease because it's demonstrated, and she had just moved in, he's never been in here, that this young lady's not going to be able to pay. And I don't want this affecting her for the rest of her life when she's already so upside down and has had no guidance other than myself with this. And that's the facts. And unfortunately, without burdening you with my problems, my life turned upside down and I am in absolutely no position to help like I otherwise would. And if that was the case, neither of them would be here today if I could help, but I can't. And so I'm hoping that sums everything up because I kind of went off script. And then if you want anything else, we have a lot of information for you, but I wanted you to know with the context with her because she's not going to share that with you on her own.
All right. Okay. Okay, Haley,
Mhm.
you're right now, is that your apartment at Spice Tree right now that I'm looking
Yeah.
at behind you?
Yeah.
Okay. So Haley, let me ask you this. As I sort of synthesize this whole thing, are you going to be able to move someplace or you just don't have anywhere to go? All right,
So
young lady, let me tell you something. Okay. Because I heard Gavin's mom say you have a lot of pride, right? Okay, is that right?
sure.
Okay, so listen, here's what you got to do. I'm just sort of a plain talking guy, okay?
Mhm.
And so sometimes to try to work some of these things out, you got to kind of set aside your pride, okay? Sometimes, and sometimes things don't work out, but sometimes things do work out, but they can only work out if there are people in a position maybe that can help. Can't do everything, but you got to kind of know what's going on with you, okay? So if it's going to be a circumstance where you're going to be homeless, you got to tell me that.
Not maybe for a minute.
What do you mean by that?
Okay, honey, it's okay.
Haley, talk to me. All right.
Well, I just I would rather just not have to keep going through with this, like the
Okay.
rent until April. So
All right.
I could find somewhere. Because
Okay,
like
now hold.
I wanted to do it all on my own. So
All right. Okay. So Haley, love. Gavin, how old are you, buddy?
I'm 21.
All right. Now, certainly, Haley, not through the circumstances, probably not through the circumstances of either one of you that you guys have been through. Let me just tell you, you're talking to somebody who losing parents is hard, right? We know it's going to happen. At least if things happen in the orderly way, that's going to happen. But we never expect it. Okay. So I usually don't share things about myself, but so that you can understand that at least to a certain extent, I can kind of understand the uncertainty of where you guys are.
Mhm.
All right. Understand, I lost my dad when I was 16. So I can particularly appreciate, Gavin, when you say you're not in a good headspace, I get it.
Yeah.
Okay. And, Haley, I can't even, I can't even wrap my head around that. Okay. But the one thing I can tell you both, life doesn't end. You find a way to make it through. Haley, for you, sometimes when I'm telling you to set aside your pride, sometimes you got to set aside your pride. Sometimes you're just not that strong, and it's okay. Okay? Because somewhere out there, while the world doesn't seem like it's a great place sometimes, I believe in the goodness of people. And so sometimes when you let that down and people can see it and you just sort of lay it bare, I got to believe, and I just do believe, that there are people around that kind of help you out. Okay? And you just can't, you know, Haley, you don't have any reason to have any faith in humanity. You just don't. And I'm not going to try to tell you that you do. All right. But slowly but surely, maybe you'll begin to see it. Okay. It'll come back at some point. Okay. But more importantly, you got to give yourself space and time to heal and time to move on. And there's no recipe for it. And you're going to come across a lot of these bumps. And what I don't want you, it's one thing to give up on an apartment. It's a whole other thing to just give up on life. And the latter of that, I don't want to see. Okay. So, Haley, if you don't have the apartment, where do you think you're going to go? You got a place?
I have a place that I can go to, yeah.
Okay, for how long?
For a few months until I can get it figured out.
You know what, Your Honor, if I may, I only want to
Yes.
say, I think she would share more with you, and I don't know if you have if you're able to do this or not. I know because her and Gavin haven't been dating since August or April, I'm sorry, that she would probably share more with you if she wasn't in this situation. And I'm not asking you to make accommodations, but I do feel like that's where the hesitation's from. I don't know if he can be removed so she could share you more during this or not.
Well, let me do this.
Okay.
Let me do this. Haley, just really bottom line is, between you and Gavin, you don't have the money to pay for this apartment, right?
Mm-mm.
You have the potential ability to go someplace. Okay, so here's what I'm going to do, Haley. I'm going. Mr. Dornbush, I'm going to adjourn this out to October 4th, 2024 over plaintiff's objection. What time?
12 p.m.
At 12 p.m. Okay.
Sir, could I say one thing though? I'm sorry.
Go ahead.
My dad's service is on the 5th, and they live down by Flint, and I was planning on being there for the 4th and the 5th. So I don't know. We could reschedule a different day.
Well, I'm going to leave it to the 4th because I think things have to get resolved for the plaintiff. Okay.
Yeah.
So I'm going to leave it that date. If you're not here, I certainly understand that, and we'll work around that some way, but you're not in the apartment in any event. So
yeah,
that may not be an issue. Okay. So that's what I'm going to do. Ms. Dornbush, I'm going to ask you a favor of you. If you don't mind, if I ask Haley to wait till the end of the proceeding, do you mind if I have a private communication with her and Gavin's mom regarding the circumstances in this case? I would never, of course, do anything detrimental to your client in that conversation, but just trying to figure out what we can do with this so some folks can Land softly. You're muted.
Sorry, Judge, I was verifying those other payments, and I'm not entirely sure what to say, because obviously the news, the information
Yeah.
that's been shared here today is frankly devastating. So, at the same time, I do have job to do, and I have to advocate for my client, and I know the court recognizes that. I would say that if during that discussion information comes to light that would otherwise affect my client's legal rights, that information needs to be shared with me. Because
Absolutely.
I do have an ethical duty to my client, but at the same time, I understand the circumstances and frankly, what Miss Salisbury's been dealing with. I have no way to understand that, but I know that there's information that the court would like to hear, that she would like to share, and I understand the need to do that privately. So, if something comes up that is going to affect my client's legal rights, I have to request that information be shared with me, whether it's in a written statement or if it's something that the court discloses.
And
Ms.
Ms. Dornbush, I would give you my word that if that were the case, and I would also apprise her that I would have to share that with you, so there wouldn't be any surprise on anybody's part. But I have a feeling there's something. Yeah. So if you don't mind, I think I will do that, and let's see where we can go and try to get this resolved, hopefully next week with this. But I think there's something that has to happen in the interim. Okay. So I'll adjourn it out a week. Haley, wait on the line. You and Gavin's mom are gonna go into a private breakout with me as soon as I get finished with these few cases that I got here, okay?
Yes, thank you, Your Honor.
All right.
This courtroom case took an unexpected turn when Jeffrey Bloom chose not to participate in the trial and later refused to appear for the verdict. Despite being informed of his right to be present, Bloom voluntarily waived that right, leaving the court to proceed without him. The judge carefully ensured that all legal requirements were met and instructed the jury not to let the defendant's absence influence their decision in any way. As closing arguments concluded, both sides presented sharply different versions of the events, leaving the jury with one crucial task: determining whether the evidence proved guilt beyond a reasonable doubt. In the end, after reviewing all the testimony and evidence, the jury returned a surprising verdict of not guilty. The outcome serves as a powerful reminder that courtroom decisions are based on evidence and legal standards, not emotions, assumptions, or a defendant's decision to stay away from court.